Hello everyone, welcome to what might be my longest video so far, because we're about to go into the 50-minute rant of Darrell Brooks. But this moment in trial is not something that you just watch. This is something that you experience. You cannot just go to someone and ask them to watch this video alone, because they wouldn't get it. You need to know how we got there, what happened, and what happened after. And that's what we're going to do in this video. Right now, we're about to go into Judge Doro and what triggers Darrell Brooks into this tirade. But before that, I just want to say thank you to everyone. I always feel blessed that, and I feel honored that you guys take time out of your day to watch one of my videos. It's incredible. Thank you for the likes. Thank you for the comments. Thank you for being here. I'm a really grateful person, and I truly feel something inside me that warms me up when you guys watch my videos. So thank you guys for that. Okay, without further ado, let's get into the video. It's gonna be a long one.
To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that. Those are legal determinations that if you feel there is an error later on, you can address on appeal if you are convicted. I have been answering many of them at your request, but I may not do that at all times. In fact, you're asking me to provide that explanation and really highlight for the jury the court's opinion on relevance. That's why we don't state that. There's an objection, it's a party makes it, states the grounds. Sometimes I ask the opposing party for their position. Sometimes I do not. Many times it's very self-evident. Either the objections are baseless. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay. So that's why, to me, they're self-evident. I say sustained, and we go forward. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury, which I don't feel is necessary for the reasons that I've already stated, that you're asking me to highlight my opinion on relevance and my determination on relevance. So going forward, you need to be aware of that. Again, not a sign of disrespect. It's the record is self-evident many, many times. If I feel that more argument is needed, I'll excuse the jury. But I haven't felt the need to do that up until this point.
Okay, so I wanted to let Judge Doro say all of that because it's really important. She just laid it out to Darrell Brooks why she's not doing, why he's doing 345 grounds so far in this trial. And it's baseless because you're highlighting to the jury why you are wrong. When you say objection hearsay, and the judge has to say it is not hearsay, it highlights to the jury how incompetent you are. It paints you in a bad light. That's why she doesn't want to say it all the time.
And I will caution you once again, sir, 906.11 is the statute, mode and order of interrogation and presentation controlled by the judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. A, make the interrogation and presentation effective for the ascertainment of the truth. B, avoid needless consumption of time. C, protect witnesses from harassment or undue embarrassment. And it goes on, but for purposes of what I'm going through, that's the most relevant portion of 906.11.
Also, another explanation for Darrell Brooks, 906.11, when he starts asking questions about the defendant, about the state of Wisconsin, about all of that, that is baseless, that it gets us nowhere. That's why she can cut him off. And that's why she should cut him off earlier, but that's neither here or there. But she doesn't have to hear that. He doesn't need to ask that. That's why he gets cut off.
So when I give you the warning that under 906.11, I will cut off your cross-examination, it's because you're violating 906.11. So
is that a judicial determination that I violated 906.11 when
I'm advising you, sir, it's not a specific determination as to anything that's happened thus far, just a summary of why I am relying upon 906.11 throughout the questioning of witnesses and the presentation of evidence.
Your Honor,
So with that, we're going to continue. I'm going to have the state be ready with their next witness.
Your Honor, I'm not interrupting you. I'm letting you make a clear record.
I'm not interrupting you as he is interrupting her. And another thing that I hate about the way he's saying this, I'm letting you. You're not letting her do anything, Brooks. She can kick you out and she will continue to do what she's doing. You're not letting anything happen.
Mr. Brooks, you have actually interrupted me.
I just let you go through the whole citing of 906.11 without saying anything.
I'm not asking for the parties to make an argument under 906.11.
So
I'm advising you. Stop interrupting me, please. I'm advising you, sir, so that you have hopefully more knowledge and awareness as it relates to the statute that I've cited dozens of times during this trial.
I'm well aware of what I'm citing, Your Honor. Well aware.
You're not well aware of anything. You don't even know what hearsay means. Like the ego, the ignorance is showing right there.
All right, so
and I'm just seeking for the record to be clear. With all due respect, Your Honor, that's judicial misconduct because you're not allowing the jury who deserves to hear certain aspects of testimony. Like I stated yesterday, under the Sixth Amendment, I have the right to face my accuser.
No, he's so wrong. He is so wrong. And a lot of people have put it in the comments. You are not, the right is not to face your accuser. That's not what the Sixth Amendment is. You're just wrong about that. And people have explained it to you, but you don't care or you feign ignorance of that fact.
Which means that I can question about clearly the plaintiff being the accuser. How come I can't question about if a witness may know or have had any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face? Also, the reason why I was objecting the way I was is because I was trying to get to the question of the witness saying that about the four ladies in her group that were not injured. There's relevancy because with her stating on the record, clearly for the record, and for Your Honor, and for the court and for the jury that these ladies were not injured in any way, but yet there's still charges associated with these ladies who were not injured.
It doesn't matter if they were injured or not, Brooks. You were charged with recklessly endangering life. They don't need to be hit. They don't need to be hurt in order for them to be associated with that charge. Endangerment, not hitting them. You endangered their lives by the way that you were driving.
That should be dismissed.
No.
we are not at that point, sir. The charges I refer you to the preliminary jury instructions for first-degree recklessly endangering safety and the elements they don't need to prove. There are certain elements. And so I'm not going to have a debate with you over the law at this point. I've made my rulings as it relates to certain questions that you have asked and whether they're relevant, whether they're vague, whether they call for speculation, or a whole host of reasons that a question can be objected to. I'm not further going to address your position on
May I request a legal
let me
reconsideration of your
finish,
ruling,
sir.
Your
You
Honor?
interrupted me. I'm not done with what I was trying to say.
It was no way for me to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But
And you keep interrupting her anyway.
you paused for quite a while, so I wasn't sure.
In any event, sir, we're going to keep going. Any error you believe I've made, you can raise again on appeal if you are convicted, but we will proceed forward. Does the state have
I'm
their
not
next
trying to-
witness available? Please do not interrupt. I'm asking a
And that's
state
why I
question.
that's why I was
Mr.
just quiet.
Brooks, you're interrupting. Stop. Does the state have
coming
available their next witness?
We do, but could we please request a comfort break, Your Honor? I'm sorry, but we haven't gone about 2 hours now.
All right, that's
as long
fine.
as
We'll
they're out.
take a 15-minute break. That's fine.
Thank you.
You're welcome.
For the record, Your Honor, we haven't addressed subject matter, jurisdiction.
We are off the record, Mr.
And they cut off the sound there, but we come back.
Thank you. Be seated. Okay, so you have that. Okay. Do you know what time we took our break?
And now he's fuming. The reason why he has his arms crossed like that and he's staring at the judge is because he's mad. He's mad that he couldn't go earlier with his whole tirade about I'm doing this right and this is what I'm supposed to do and you're hiding stuff from the jury. Look at this childish pose.
All right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor?
All right, let's bring the jury back out.
Don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party interviewer on special appearance on behalf of my client.
You already stated at the beginning, no one cares about the way that you choose to identify yourself. You can identify yourself as a rock, and no one would care. They will still call you Darrell Brooks.
Can that be noted for the record?
It's noted.
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Yes,
I
she's
will.
like, shut up. No one cares. All right, that's part one. Let's go into the next one. We go right
Well,
into the thing.
You all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect.
Okay, first of all, every time that he says with all due respect, it's just because he has it written on that red folder. He doesn't care about respect of the judge. He doesn't have any respect for the judge or any person that is not him. He is just about to go into a full script of things that he practiced between yesterday and today. Like, remember, look, if you watch my past videos, which you should, But if you watch them, you will know that unlike the other 5 days, he went straight into overdrive with objections and grounds, trying to stop and trying to delay the trial. But we're about to go into this. I don't even know what to say it, but let's go. Let's go.
I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry?
Nonsense
I
question.
don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm
Brooks, if you don't know what kind of court you are after 5 days of trial, after almost a year of being incarcerated, you have bigger problems.
requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not.
I agree, Professor Brooks. There's been a lot of bias favoring you in this trial. She's been helping you. She's been holding your hand the entire time, and you don't appreciate that. You're asking for a document that she doesn't need to give you because she's a judge. A judge is impartial. She hears both arguments and decides at the end what's best to give as a sentence. She knows the law. Her job is at risk if she doesn't do that properly. She's not gonna risk her job for you, someone who didn't even finish high school, someone who doesn't care about their kids, someone who doesn't care about anyone for himself. And even though he killed 6 persons and hurt many hundreds more, you don't even care about that.
Been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that.
Yeah, but you need to pay for those certifications, Brooks. They will give them to you if you pay for them. They're not free. So do you have money to pay that?
My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office.
Yeah.
Which you are required to show if I ask for it. I've brought up my 6th Amendment constitutional right that has been pretty much discarded. And
Discarded.
that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim.
Again, by this logic, every single person that murders another is free. They cannot charge him because the victim cannot go and face them.
Requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond.
You don't see them because you don't look for them. They were provided to you along with the entire discovery, but you don't care to look for those papers.
In my docket sheet, I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor.
What kind of questions are not being asked to you? You are the one that needs to be asking questions.
You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor, I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time-stamped. I haven't got the original copies of any of them, which I'm supposed to get.
And again, he's not supposed to get those. The judge just gave them to them as a courtesy. But she's not entitled to them.
And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted.
And that's it. I mean, we are 5 minutes into this rant, and that's the only thing that he wants. He said it right here, 5 minutes, that's all. He wants this case to be dismissed because some random stuff that he came up with that is not right. That if it were the case, thousands of lawyers around the country will be piling up to represent him because they see a major flaw on the case, and they will want to win that case for you. But why do you think that's not happen, Brooks?
Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days.
And again, the fact that let's just say that one of the witnesses believed that another person, let's just say that Jackson, someone in the stand says that Jackson didn't die, that he believed that he was okay. He didn't see any information. Just because he says it and he believes it to be true, that doesn't mean that it is. If the grandma that was here last episode says that she was not hurt, she may not know that. She may have gotten hurt.
There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet.
Imagine the DA, the assistant DA, and the entire state bringing 3 lawyers that don't have licenses to practice. Shocking. I don't know how they're getting away with it.
There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My 6th Amendment right has been basically trampled over. No complaints have been shown. neither of the three that I've requested, by the way that you told me to request them by inmate communication, nothing is certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people.
You're not the people, Brooks. You're a person. She is protecting the people from you.
That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified?
Because they don't need to, Brooks. That's the bottom line. They don't need to. That's why it keeps going. This is all just in fairy tales that you came up with that they need to be done for some reason. Even when you brought case law, that was worthless. It was nothing that they needed to address.
Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record a non-responsive answer. A non-responsive answer is an agreement.
Yes, that applies to you, Brooks. Not to everyone. He for some reason believes that everyone in the court, including the judge, plays by the same rules, which is not the case. He controls the court. Just because you think that we live in 1864 and that if the accuser is not there, then they need to let you go. That's not how it works.
Which would be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering. I have that right.
You don't.
The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin.
It is.
But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff?
The plaintiff is being represented by people. People can represent someone, something in this case. Just like you are representing as a third party to your client, they can represent. Where is your client, Brooks? If you are not the client, who it is? Where is it? Why is not in the courtroom? How can they release someone that doesn't exist?
Who's bringing the claim?
I hate his hands.
Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has.
Excuse me, but there's been people that say that they're the injured party. Witnesses, the testimony of the witnesses that you keep bringing up, they said it.
Stated to be an injured party in this matter.
Yes, yes they did.
No one. Not one person.
Gaslighting.
I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Has that been placed in the evidence? I would like to see it.
What unrevealed contract? There are no unrevealed contracts, Brooks. How can they give you something that doesn't exist?
Which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge?
And here, everyone, we have what is called revealing your hand. Brooks just said the quiet part out loud. He revealed his strategy, which is manipulating, gaslighting the jury in order for him to go free. So they don't unanimously, beyond the shadow of a doubt, find him guilty. He just said it.
That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that.
Do you want to change your plea to guilty, Brooks? We can do that right now, and this can be over.
Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue.
He's so scared.
I
just noticed that he's so scared right now. He's fighting for his life. Like, I'm gonna come back as a 5 seconds and look at his hand. Look at his left hand.
The prosecution even wanted to offer a plea.
Look at that. He's shaking. He's shaking. He's so scared.
That's another issue.
I think by this point out of the trial, after he saw the grannies get hit, and the jury also saw that, he's so scared and he's in panic mode about it.
I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that.
You don't even know what that means, Brooks.
I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year.
Well, maybe don't fire your attorneys that have been prepared for that same time, and you will have the upper edge.
We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days?
That sounds like a personal problem, Brooks.
That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least at the minimum it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied.
Yeah.
No valid reason.
Because when you wanted to get rid of your lawyers, she told you, I'm not moving this date. You still want to do this. And you say yes.
Reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor?
Why would she do this? She doesn't have to. She just hears the case. She doesn't make claims.
Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until the appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That
I love how his voice cracks sometimes. I'm intending to do. No, Brooks. If you wanna say that you're gonna appeal, you can, but you cannot appeal until a decision is made. What if you're appealing and at the end you are not guilty? You want to appeal that decision?
It's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention.
Never isn't your intention. Well, that depends, Brooks, because you have rights, yes. But what about your Second Amendment right? Do you have that right now? I don't think so. And also you are in a courtroom, which means that you need to know how to address something. You cannot just say stuff. That's not how it works. You cannot just continue filibustering for 8 hours every day because you have the right to be heard. No, there's a procedure. There are ways to do it.
I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation.
She just gave you, 18 minutes ago, she just gave you an explanation of why she's doing it. He doesn't have a memory. He's just reading what's on the paper and is following his bullet points.
I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right.
You did, Brooks. There was a judge before Judge Doro, and you said that you didn't want him. And they gave you Judge Doro, so that right was respected.
I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past.
Yeah, so take it off in appeal. Make your entire basis of your appeal that they didn't give you a speedy trial when you never asked for one.
Change of venue motion was brought up. I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County.
But that's just speculation, Brooks. I don't watch the news. I didn't know who you were until the trial went public. So I didn't know anything about you. So they might do that as well. And there was a jury selection phase where you could have just remove people that you think that will be biased against you. But you didn't do that. Also, this case is so open and closed with the way that the state put it together that I believe that it doesn't matter where it is. It doesn't have to be in the United States. I'm sure that if you go to Argentina and present the case in English with the evidence that you have, you will still be guilty with people that never heard anything about you. They just need to see the video of you running over people with the pictures of you driving the car, and that's it. You're guilty.
That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours.
Hey, Brooks, how do you know that? I'll tell you why. She told you. She said it. She was open and honest about it. And no one raised an objection to that. That was the time. Now it's too late to be crying over spilled milk. If you had an issue with that, you should have told her when that was brought up. But you didn't.
You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and
I highly doubt that. I don't think you've had many jobs. Oh, maybe an hour job or maybe 2 days jobs, but I will be hard pressed to believe that Darrell Brooks held a job for over 2 months.
I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I can reach out immediately when I learn something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again.
You already said that.
In terms of when I asked for the motion for the evidence motion that I raised.
He doesn't even remember.
That was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract.
There's no unrevealed contracts. There are no unrevealed contracts, Brooks. That's why you don't have one.
Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that.
How is this relevant?
There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery?
Because you said it yourself. It's 3 boxes of 40 pounds of documents. It takes a while to put that all together.
Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses.
You did.
I did everything that was asked of me by the court pertaining to those subpoenas.
Yeah, you sent them.
It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance.
No, they said that they will help you deliver them. They never said that they will help you fill them. He wanted to just give them the names and they do all the paperwork. You need to do something yourself, Brooks.
The only assistance I received was for them to check to see if it was filled out right.
Yeah.
That was it.
Yeah.
That doesn't amount to any assistance. I was still left to fill it out on my own. And then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this.
And who helped you with those corrections, Brooks? How do you end up with all the subpoenas in the hands of them, being ready to be delivered? Who?
But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed? And how could the plaintiff not be called to the witness stand?
Because it's an entity, Brooks.
That begs the question of, does the plaintiff even exist?
Yes.
Which it was stated for the record that not only by a witness, a detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being.
Yes, Brooks. He said that he was an entity represented by the people on the state's table. That's enough.
And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom?
No.
No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction.
No, we're not. You are talking about it. No one else is talking about it. We are not a thing.
That's been being asked for over a week. There's still no providing of licensed to practice law yet.
You already said that.
Not even by you, Your Honor.
You want the judge to present you with her license to practice law. Why exactly? You think that she doesn't have one?
Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked.
Because she changed her name, Brooks. She finished school with her maiden name, and then she got married. He's trying to imply that the names on different papers are different. But that's because she wasn't married back then.
You referred to your name tag, but that's not the name registered. We both know that.
It's not the
So
gotcha
why
that
wasn't
you
that
think.
proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which
You
is
did.
the main reason why I subpoenaed the plaintiff in this matter.
The plaintiff is not a witness. It's an entity that helps all those people that you hit or endangered to bring a case against you. The entity represents those people. He doesn't even know anymore. Like right now, we're done. Like I said before, he was done 5 minutes in, but now he's done even the extended version. He's going through his papers to see if there's something wrong, and he's just gonna repeat himself.
I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people.
They do. Are you gonna challenge first degree murder? Because that's what you did.
From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people.
Yes. And the people, everyone, not just you, the people come up with these laws and they decided that you break them. You're not the people, Brooks. You're a person. And what you believe a law is doesn't matter. Doesn't matter what you believe. You can believe all you want, but they don't have to go by what you say.
You know this, Your Honor. Are you not a public servant? You also know that this docket sheet is inaccurate.
You already said that.
Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name.
Okay, here we go. This is the issue with his name. This is why he is the third party representative and all that stuff that he says. Just because they wrote his name in all capital letters, which is common to do. Everyone does it. It's in every document. So this is why he doesn't recognize that all these charges are against him, because he is not Darrell E. Brooks with all capital letters. It's dumb.
Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client.
Who is the client?
Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up
Okay, at this point, I need to break from him talking a little bit, but I just want to say the reason why Judge Doro is letting him go as long as he's going is because it's like the same as a child, where you let him cry because he didn't got a toy at the store, and you just let him get it out of his system. He is hoping that by allowing him to speak this much, he's gonna get it out of his system. He's gonna forget about it. She's gonna address all those things, and then he's gonna move on. It doesn't happen, but I get why she did it.
Illinois versus Allen, when we had the issue of me being removed from the courtroom. We went through that, where Illinois versus Allen states that there are three options when a defendant is being disruptive in court.
No, it says that there's no single answer to that, and then it lists three examples of it. Then Judge Doro interpret that as being more, and that's what we're using. That law was made over 40 years ago. We didn't have HD cameras and microphones back then. Laws adapt to the times. You're gonna say because a law doesn't specifically says that a video camera can be used on court, that means that never a camera can be in it. It's a very ignorant interpretation of the law, Mr. Brooks.
You stated for the record that you identified a fourth one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a fourth option that's not written in that case? Did you take it upon yourself to add this fourth option to justify denying me my constitutional right by being present? You could have done the three that were stated. Any one of the three you could have done that were stated in the case.
Oh God, I wish they could have gagged him. I would have loved to see him gag inside the courtroom. But there are dreams that cannot be.
Nowhere does it say you can create a fourth option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason.
And this is very heavy. He doesn't realize how heavy it is because he's an ignorant fool. But accusing a judge of treason inside her courtroom, I don't believe there's anything more disrespectful than that. It's incredible that he believes that he can come into that and say that and not go. I mean, they have more patience than I. Let's just say that.
You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about are you making judicial determinations, I'm repeatedly shut down.
Are you done?
Which leads to today.
Okay, we're at today now.
The constant push not to have an informed jury. Not giving legal valid grounds on objections. Not noting objections for the record to make sure that the record is clear.
It did though.
I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff.
Yeah.
That's clear bias. And it prejudices my defense.
You don't have a defense. And that's the main point. You don't have a defense. The only defense that you have is try to discredit every witness that goes in the stand, which you cannot do because they're witnesses that were there, that saw their family, their friends, their neighbors die or get hurt or multiple things.
You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately.
Yes, because they are filing evidence while the trial is going on. It's proper. A subpoena, you missed your deadline with the subpoenas. So you have to wait.
I have to wait, or I have to wait till the next day.
Yeah.
That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel.
Yeah, you gave up that
It doesn't
right.
say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things.
You want assistance, Brooks? Hire someone. What they say is that they were not going to give you anything for free now. But you have all the right to hire someone, pay them to do assistance for you. You have the right to do that.
You, Your Honor, gave me paperwork that was a waiver of counsel.
Yes, that at the bottom it says that you cannot modify this paperwork. Very clearly, it said on the bottom that you cannot modify this in any way. You cannot scratch some parts, you cannot put some words like you wanted them to be. You cannot.
We both know that any contract can be altered if I don't agree to certain terms.
No, it can't.
I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered.
Notice how easy it is for him to claim that everyone understands something when he doesn't understand anything. But everyone else, he's dumb. He's a little child that is in the courtroom wearing an oversized suit. He doesn't understand. Everyone else understands, but he doesn't.
You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement.
She put exceptions, Brooks, objections. She put several things on the record to make it clear that what you were doing was knowledgeable, if you know what I mean. She did. She did that. You're not going to say it because you want to try to rewrite history, but she did it.
But yet, I'm still forced to come in here with zero help.
You have your mom.
I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And
yes, because they're prepared for it. They study it. They know how to do it. You don't.
I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day.
Right.
Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form, general population with an upcoming trial.
Brooks, the reason why you are not in general population is because you wouldn't survive general population. You wouldn't. The reason why you are alive is because the jail is allowing you to be on your own.
Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be
The law library. What is a library? ¿Dónde está la biblioteca, Brooks?
the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells.
Right.
That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it?
Maybe you should have thought of that before committing a crime. Then you would have, then maybe if you went to law school and you go through that, maybe you will have time to go through all that case law. But you decide to commit your life to crime, to go the easy way. And look how that worked out for you.
I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed.
He feels so special. He wants special time, special treatments. He wants the judge to give everything to him. But that's not how it works, Brooks. When you decided to be on your own, you would either need to have money to hire someone else or just stick with what you had.
And to be frank,
You're not Frank, you're
in a
Darrell.
proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude.
Imagine this in another scenario. Let's think about a race. If for some reason I take a knife and cut my leg before the day of the race, and then I ask everyone to stop everything because I did this to myself and I cannot run, or that everyone should just run in one leg while I am running when I crawl into the finish goal. How does that work, Brooks? It's not real world. You don't get a special treatment. Everyone in the race is going to try to do their best. Just because you handicap yourself doesn't mean that everyone needs to feel sorry for you and help you.
Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still that was denied. It's impossible for an impartial jury to be found in this county. And that's not to discredit people in the county that can be impartial.
So no one can be impartial or people can be impartial, Brooks. Pick one, because you said both in this back to back. So either no one can be or some can be, or what is it?
It would be unfair to say that no one can be impartial.
Right.
That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this.
There are YouTube channels that are created because of this. But how do you know that, Brooks? You don't have access to the outside. How do you know that this is real?
The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said.
Please don't say anything insensitive or nasty in my comments about people. So Darrell Brooks, you can. I approve of that.
The sheer insensitivity of some of the things that are said on there.
Cry me a river. The murderer that has no empathy or sympathy, anything against his victims, are trying to make me feel bad for what I said about him because I said a nasty comment. Poor Brooks.
I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too, family too, loved ones too, that also have been ridiculed and had their names drugged to the mud and have threats towards them.
Whose fault is that, Brooks? Who made them that? I'm not condoning attacking other people around his family because, well, their kids don't deserve it. But who was the catalyst for that to begin?
Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug.
Sure.
Whatsoever.
Wait, are you admitting that there's stuff to put under the rug? Are you self-admitting that you did it right now?
To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite.
The guy that did the tragedy is calling everyone out because they're not saying that it's a tragedy. I guess he has the moral ground to us.
And that will never be swept under the rug. There's always going to be healing that has to take place.
Right.
It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many, many, many other victims that never is talked about.
And those many victims are not the families of the real victims. It's his family. He wants Judge Doro to feel bad about his family and himself, because he's a victim now. He's a victim of nasty comments. He's a victim of all of this. Feel bad for Darrell Brooks.
And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true.
All right.
I'm sure the court read through the motion for change of venue.
Here we go
I'm
again.
assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close.
Well, the law says that you need to be judged by a jury of your peers. How they are not gonna be your peers if it's anyone else, any other place?
If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero.
All right.
There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction.
I love that. I love that he just went on a full tirade about something that doesn't even matter, and he needs to bring it back to jurisdiction. The first thing that he needs to come back to is jurisdiction. We haven't proved that.
We still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech.
Yes, people prepare for declarations that they need to be really precise about, because they don't want something to be left to the imagination or interpretation. He believes that because people prepare, they're scheming something. It's not like that, Brooks.
That was obvious. Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case?
You already asked for that.
there still is no proof if you hold the full judicial power of the state, or is it the military power?
We're about to start again. We're about to go into another 50 minutes of him reading all those points back to back again.
Mr. Brooks, I've given you about 50 minutes.
Okay. All right. I've been talking for about an hour and a half, so I'm gonna leave it here. We're gonna come back with the judge and attorney Opper when we come back. But thank you guys for watching. Have a wonderful day, and remember that you're great, that you matter, and that I'm really happy that you guys are here. I'll see you on the next one. Bye-bye.